And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
One wrong sentence during a traffic stop and your lawful gun ownership can flip into a felony charge in the blink of an eye. I am talking about exact, specific phrases that officers are trained to listen for and then repeat back in court against you, even when you believe you're being helpful, truthful, and cooperative. Today, we're unpacking the 5 most dangerous words and phrases that gun owners tell the police that absolutely wreck their legal defense. By the end of this video, you're going to know precisely what to say, and more importantly, what to never utter when an officer asks about your firearm. This isn't just a hypothetical scenario. Just last month in Texas, a licensed concealed carry driver said only 3 small words during a routine stop. Those 3 words cost him his carry license, $15,000 in lawyer bills, and 24 months of grueling court fights. He thought he was doing the right thing. He was dead wrong. The first phrase that will destroy you is, "I didn't realize." Think about this scenario. An officer realizes you're armed inside a forbidden zone. Maybe it's a post office lobby, a school parking lot, or a city building where carry isn't allowed. Your first instinct is to explain yourself. You want the officer to know you're not a criminal, so you say the most common reply, "I didn't realize that was illegal." Here's the legal trap. Under the rule of ignorance of the law, saying you didn't realize something is not a defense. In fact, it's an admission of guilt. You just told the officer in the court that you performed the act. You carried a weapon inside a restricted place. The only issue left for the prosecution was intent, and you just handed it to them on a silver platter. You erased any argument your lawyer could have shaped about lack of knowledge. In 2023, a carrier in Louisiana said exactly this when he was spotted armed in a courthouse garage. The district attorney used his own sentence against him as proof of the violation. The result was a Class B misdemeanor, a $2,000 fine, and he was forced to surrender his license for 3 years. His attorney later admitted the case might have been tossed if he had simply stayed silent. If an officer tells you you're in violation, volunteer nothing. Your single reply should be, "I'd like to consult with counsel before answering any questions." That's it. Let your lawyer tackle the issues of knowledge and intent later, once they've studied the statute and crafted a real defense. The second dangerous phrase sounds cooperative, but it's a legal minefield. "It's only in my pickup." Imagine you're stopped for a busted taillight. The deputy asks if there are any weapons in the vehicle. You want to sound like a good guy, so you answer, "Yeah, it's only in my pickup," or "It's only in the glove box." That tiny word, "only," legally equals an admission of both possession and control. In front of a jury, the state will argue that you knowingly placed the firearm exactly where you described. If that spot happens to breach a local rule, maybe you're parked near a campus or you crossed a state line with tougher storage laws, you just gave them every element they need to convict you. In Florida, back in 2022, a driver told a trooper his handgun was only under the seat. The trooper found it loaded and not in a locked container. Under the local statutes, that was unlawful without a specific carry license. The driver actually had a license, but it had lapsed only 2 weeks earlier, because he described the exact location and accessibility. The prosecution was able to prove he had instant access to the weapon, bumping the charge to a 3rd-degree felony that carries up to 5 years in prison. If state law forces you to notify the officer, keep it clinical. I'm informing you that I am a licensed carrier. Period. No details on the location, no elaboration. If they ask where it is, you reply, "I'd rather discuss the details once my counsel is present." It might feel awkward or uncooperative, but cooperation at the roadside, it does not mean volunteering data that will be weaponized against you later. The third phrase is one that leads to more arrests than almost any other, even though it seems like the right thing to say. "I possess a license." Now you might be wondering, aren't you supposed to declare that? Well, it's not the announcement that's the problem, it's what follows. Picture this. You tell the deputy you have a license and he demands to see it. You reach for your wallet, but then you realize your license expired last month and you forgot to renew it. Or maybe you moved and didn't realize your old license isn't honored in this new jurisdiction. Now, you've just given a false statement to an officer. That is a separate crime in 43 states. In Virginia, for example, it's a Class 1 misdemeanor that can get you a year in jail and a $2,500 fine, totally separate from any gun charges. In 2024, a permit holder in Tennessee told a deputy, "I possess a license," during a stop. When the deputy ran the database, he found the license was suspended due to an unpaid citation from 6 months prior. The driver had no idea about the suspension, but the DA charged him with carrying without a license and giving a false statement. He ended up with $8,000 in legal fees and a permanent entry on his criminal record. The safer way to word this is, "I am a licensed carrier, and I would prefer to confirm my status through my counsel before we continue." If the card is valid, your lawyer confirms it, and you're clean. If there's a glitch or an administrative error, your attorney handles it before you've said anything the state can quote in court. The fourth phrase feels like you're asserting your rights, but it actually gives prosecutors proof of intent. It's for safety. When an officer asks why you're armed, you want to sound sensible and responsible, so you say, "It's for safety," or "I carry for self-defense." You just established your motive and your intent. If your carry scenario is later ruled illegal for any reason, like being in the wrong zone or a reciprocity issue, the DA now owns your own words proving you meant for that weapon to be accessible for use. That intent can upgrade a minor offense into a much more serious charge. In California, which has some of the toughest laws in the country, a CCW holder was caught armed in a posted no-gun zone. When asked why he was armed, he said, "For safety, there's been a lot of crime around here." The prosecutor used that exact line to argue that he deliberately and willfully ignored the signs because he valued his personal safety over the law. That turned a possible misdemeanor into a willful violation, costing him $12,000 and 18 months of his life fighting the case. When asked why you are armed, the only response that shields you is, "I wish to speak with counsel." Do not rationalize, do not elaborate, and do not feed them material. The fifth and final phrase is the one that obliterates more defenses than anything else, and it usually comes out during a panic reflex. "I wasn't planning to fire it." When a deputy finds your pistol and you want to calm the scene down, you might blurt out, "I wasn't planning to fire it," or "I forgot it was even there." Congratulations, you just confessed to unlawful possession while simultaneously wrecking your Fourth Amendment protections. When you say you weren't planning to fire it, you verify that you knew the firearm was present. That removes any claim that the gun was planted or that you were unaware it was in your car. You just locked yourself into legal possession. If you say you forgot it was there, you are admitting to negligence. In states with mandatory storage laws, negligence is a crime all on its own. And if you say, "I never touched it," you're inviting the police to check for fingerprints. If your prints are on that gun, and they will be if you own it, you've now made a false statement to law enforcement. In Georgia in 2023, a driver had a pistol visible on the rear seat. When the trooper walked up, the owner panicked and said, "I'm not going to fire it. I just forgot it was back there after the range." Because of that admission, the trooper cited him for improper storage. Under the local code, it should have been a simple $100 ticket, but his statement elevated it to a misdemeanor with a $1,000 penalty and a mandatory safety class. The correct reaction when an officer locates your firearm is absolute silence. It feels brutal and it feels unnatural, but you must understand that anything you volunteer in that moment is designed to do two things: protect the officer and build the prosecution's file. Nothing you offer will make the stop go better for you, but it can certainly make it much worse. Let's recap the 5 phrases that will wreck you. Saying "I didn't realize" is a confession of guilt. Saying "it's only in my pickup" proves possession and control. Saying "I possess a license" exposes you to false statement charges if there's any error in the system. Saying "it's for safety" establishes the intent that prosecutors need to bury you. And saying "I wasn't planning to fire it" confirms your knowledge and destroys your Fourth Amendment defense. Any one of these lines could cost you your savings, your license, or your freedom. When the police inquire about your gun, your only safe sentence is, "I am exercising my right to stay silent and I want my counsel present." If you found this information valuable, please hit that like button and subscribe to the channel. We are closing in on our 10,000 subscriber milestone, and every single one of you makes this work possible. Your support helps us keep bringing you the truth about your rights and how to protect them. Stay safe, stay smart, and stay armed with the law. I'll see you in the next one.